We'll get going. Introduce myself. My name is Corey Perna. I'm a principal at BGM. I'm excited about the panel that we have today. We're actually there. This is going to be a two-part series, which today we're going to do an overview of the estate planning under the current law, which part of that conversation is potentially sunsetting at the end of the year. And then the second webinar will be June 4th, which will send out an invitation to everyone. And that'll be more of an in-depth look at strategies to minimize estate taxes. Again, I'm excited about this panel. And usually when you're dealing with this subject matter, it's always good to have your attorney, CPA, and a trusted advisor work together to create the best plan for you and your family. Yeah, I just want to let everyone know that this is a collaborative webinar, so please ask questions. If the questions will be answered a little later, we'll answer them later or during the time they ask them. So please ask questions again, as this is a collaborative. And then finally, last administrative item is we will be sending this out, recording out to everyone, as well as with contact information. And just a quick introduction on our three panelists. Rachel Dahl, she's a partner at law firm at DeWitt. She's a seasoned estate planning attorney who advises individuals, families, and business owners on matters ranging from wills and trusts to charitable giving and succession planning. She's got a deep understanding of both taxable and non-taxable estates, and she brings a lot of clarity and strategic insight when she's dealing with complex planning decisions. Then the next individual is Leonetta Rence. Leonetta has extensive experience in trust administration and estate planning. She specializes in guiding high net worth individuals and families through the complex wealth transfer strategies. Her expertise and insight are invaluable as we navigate the evolving estate and trust landscape. And finally, I'd like to introduce my partner, Michael Andrews, with BGM. He specializes in estate and trust planning for high net worth individuals, families, offering strategic guidance on wealth transfer, tax efficiency, and legacy preservation. He has a deep understanding of complex estates, and he brings both the technical expertise, but then more importantly, practical insight to help clients achieve their long-term and generational goals. With that said, Michael, love to have you kick us off. Maybe just kind of going off, what is the current law that we're dealing with in the estate world?
All right. Well, thank you very much, Corey. And just out of an abundance of time, I'm first going to provide.
He froze up.
Important to know, where we were and where we're going. So, first of all, the estate and gift tax is imposed on bequest at death and on lifetime gifts, and the rate of tax and the level of exemption have been under discussion for some time and continues to be a topic of discussion with Congress but up until 2013, temporary provisions were in place for several years, but the American Taxpayer Relief Act of 2012 established permanent rules for the estate and gift tax, and at that time, the estate and lifetime gift had a combined exemption amount of $5,250,000, and that continues to be indexed for inflation. So the estate tax rate on the taxable portion of your estate, which that's the amount over the exemption, and we'll get into what that currently is, but it's 40% for federal tax purposes. So we're not talking about state right now, but for federal purposes, that's 40%. And the exemption from the estate tax applies to not only the value of your estate, but also taxable lifetime gifts that you made in aggregate. So that means that, if you've had taxable gifts during your life, that reduces your current federal exemption that's available to you when you pass away. And in regards to gifting, So there's an annual exclusion for gifts to each person. And that has also been incrementally indexed for inflation over the years, and usually it's in $1,000 increments. So back in 2012, there was a $13,000 annual exclusion, and that's $19,000 for 2025. So for 2025, a husband and wife could gift $19,000 each to one person, and there would be no estate and gift tax exemption used. There's also no gift tax consequences for amounts paid directly to a medical provider or directly to a qualifying educational institution for tuition. So if you write a check directly to the medical provider on behalf of someone, that's basically a tax-free gift. And also qualifying educational institution, if you make a check directly to that institution, then that is also not subject to gift tax. So all this history is great, but you're probably saying, well, where are we today, Michael? And I'm glad you asked that. So the 2017 Tax Cuts and Jobs Act, and that's effective from 2018 through 2025. So note that I said 2025. The exemption level was double. So that current exemption level stands at 13,990,000. And that's up from last year of 13,610,000. So just to give you an overview of, from a gifting standpoint of how the old exemption, so that's the amount prior to this doubling from the Tax Cuts and Jobs Act in 2018. And I say this new exemption, which is the Tax Cuts and Jobs Act, that additional exemption. I'm going to pull up a spreadsheet, and then hopefully that kind of helps you out, and at least for all the visual learners, and kind of understanding how this works. So hopefully everyone can see my screen at this point. So starting from the top, and the IRS and everyone else loves to use acronyms, but I'm gonna kind of break this down a little bit of what this is, and provide you a little bit more. But this is called DSUI, and what that means is called Deceased Spouse Unused Exemption. So let's say that you have a husband and a wife, and one of them pass away, and all the assets go to the surviving spouse, and in which the unlimited marital deduction applies. Well, if a portability election is made, that DSUI amount can be ported over to the surviving spouse. So not only would that surviving spouse have their own exemption, they could also have additional exemption from their surviving spouse for the amount not used. So I do want to just talk about this briefly, but this is not automatic. So it is important to note that you must file an estate tax return in order to have this available for that surviving spouse. In addition, one thing that I note on gift tax returns, so when one spouse passes away and a portability election is made, there's on the gift tax return for gifts made after that spouse had passed away, there's actually a spot on the gift tax return where you list your spouse, when they passed away, and that amount that was ported over from that deceased spouse to the surviving spouse. So it is important that you do list that on the gift tax return, and that you show that on that gift tax return. So that way they do get the benefit of this additional exemption that they have available, because this is kind of how the gift tax works. So it first reduces the DSUI amount, and that amount would have came from a deceased spouse to the surviving spouse. Then it used what's called this old exclusion. So that would be the amount prior to the Tax Cuts and Jobs Act increase. And then any gifts reduce this TCJA amount. So it's really important that if you're thinking about making large gifts, that you really make gifts in excess of this old exclusion amount, because once it sunsets, if you didn't take advantage of this new exclusion, this TCJA exclusion, then you're not going to get benefit from that. It's going to go away. So really think about if you have the ability to gift away more than the old exclusion, it would really be a wise choice to think about doing that, especially this year with the potential sunset. In addition to just considering the current exemption levels, there's also other kind of, I won't say non-financial things that go into consideration when you do this is, one, what type of assets should be gifted. So that could vary depending on, one, what you want your level to control to be in that particular asset. Also, depending on if you give away low basis assets or high basis assets, or you want high appreciating assets, all these things should be considered. And we'll dive into a little bit more about this in the presentation, but I think with this overview, I'm going to pass it over to Rachel.
Can I interject one thing? I
Of
just
course.
wanted to let everybody know that it's really important that when you're working on your estate plan and going through these calculations that Michael has so graciously put together and explained, that you have this conversation with your team of experts so that nothing gets missed and you're, checking the boxes where the boxes need to be checked, and got somebody making sure that there is some oversight to get that done and done correctly.
Thanks, Leonetta. I couldn't
Thank you,
agree
Lynn.
more with that statement. And Michael, thank you for the recap. As I think most of us have heard the old adage, there's two sure things in this world: death and taxes. And boy, this year, I don't know that we can say that about taxes. So when looking at putting this presentation together and how we advise our clients, we now have a Trump White House. The Tax Cuts and Jobs Act has been around now for a handful of years. And, we don't have a crystal ball. If you would have asked us a year ago what we would recommend or what we thought was going to happen, boy, we might have answered in a different manner. And so could we see at the end of this year, this law be extended? Perhaps. Could we see something replace this law? Could we see estate tax at the federal level it'd be repealed? Maybe. Okay, we don't know, but what we know is what the law is today. And as what Michael was indicating, we have this amazing window, this opportunity to capitalize on this high exemption amount. And particularly for affluent families, this really can make a huge difference in terms of what they are able to pass on to their families if they take advantage. And so for the next 6 to 7 months, going back to Leonetta, what you said, it's really critical that people get in and start having conversations with their team, CPA, CFP, or financial advisor and attorney to start understanding what the options are. And that's why there's a sense of urgency here with this. Truly, there is an urgent need to do this. I think what we recommend is that if you are anywhere close to this federal exemption amount now, and certainly if this law stays what it is and we do see a sunset, it's going to be a substantial departure in terms of what families are able to pass on in a tax efficient manner. So realistically, and I'll pose this to Michael and Leonetta, you too, but I think having people understand what does their estate, what's the value of someone's estate? What makes up someone's estate? Because I think people might be thinking of maybe the bigger items, so home, marketable securities, but that really isn't the extent of it, is it?
No, it's not. Michael, did you want to jump in? I have a great
ahead, Lisa.
example for you guys to think about. We, like Rachel said, we tend to think about our marketable securities, assets that we have in the bank, possibly some assets that we have in our safety deposit box that may have some significant value. But we live with things day to day that we don't necessarily think about. They're our possessions and we don't look at them as treasures. And because we're interacting with them in our house on a day-to-day basis. I had an attorney that was working on an estate plan for a single woman in her 80s. And she came into his office and, you know, she was explaining to him what her assets were. And they came up with a great plan that would take advantage of the tax exemptions that were available to her. And about a year later, she passed away. And we had to have somebody go in and do an appraisal of the contents of her house because there were no family members that could give us this information. And the woman who went in to do the appraisal was an expert in antiques and those types of assets that you might have in your house here or there, and discovered that this woman had about $5 million worth of antiques in her house. Now, she lived with these day to day, so didn't even think about them as being a collectible and having a significant value. So a basic estate plan that had been put in place based on the information that she had given the attorney kind of blew up in our face because now we had an estate that was exceedingly in excess of the exception. So we had estate taxes that were due on the estate, which reduced the amount of money that could pass on to the beneficiaries. So when you're thinking about the types of assets that you have, you kind of need to think about, you know, what do I have? Do I have a collection of cars? And, you know, those types of things. You might drive them, you may use them for exhibits, but, you know, how often do we get them appraised? Usually for insurance purposes, but that doesn't necessarily mean that that's the tax appraised value of those assets. So it's just one of those things that we need to think about. It's just not our marketable securities and what we are holding in our safety deposit box in our house. It includes collectibles, which can have a significant value.
Right.
Yeah.
And, oh, go ahead, Michael.
Oh, that was Corey. Yeah, I was just going to mention that I've got a neighbor that is similar, just the amount of gold and with gold value being as high it is today, just a shocking number. As well as a lot of our clients that they own a privately held business, so we have a fairly affordable way of giving them, hey, here's a reasonable valuation by looking at the market and so forth. So it's not a full certified valuation, but it uses the same metrics and information that's efficient to give you an idea of, hey, this is the value of my company and here's how it plays into the overall estate.
That's a really good point, Corey. And, you know, it turns out that the IRS really is not a fan of the American taxpayer serving as his or her own appraiser in any way. And so, you know, right now with this urgency, know that if we're going to be looking at utilizing larger gifts to capitalize on this large exemption amount, to take advantage of leveraging that, evaluation or appraisal on assets is really essential. And, that is something that takes time to set up, to have done, to receive. And so it's just one more thing to factor in terms of the time crunch we have this year in order to get things done. But yes, and going back to Leonetta, what you were saying, it really is everything that is added on. And you might not think that what you have rises to the level of a certain value, but you could be very wrong about that. And maybe what you had 5 years ago, even if you did do your planning, assets, we want them to appreciate. Okay, you want your money to work for you and to grow for you. And when that happens, that appreciation is, of course, now part of your estate. And so, what we're seeing from the legal planning perspective is that folks that have yet to do a plan, or maybe even if they did do a plan, thinking that we have this really high exemption amount, they don't have to worry about something. Well, now we're seeing this drastic reduction in that perhaps, and at least under current law, and maybe in this time, your assets have appreciated. So now you have really a double whammy in terms of what we're seeing. And so I want to really address two mechanisms today that folks can take with them in terms of, I guess, strategies or things that we think are going to be topics you're going to continue to hear about. And the first is, well, what should you be doing? What type of plan should you have? Understand that planning is really a unique process, and it's based on what you have, what are your assets, what are the values, what's your income stream, what do you need for retirement, what can you afford to gift, what are the family dynamics in play here, right? Because the tax tail should not wag the dog, even though this is a big topic. But those are things that we want to take a look at with you to ensure that your goals are met and your wishes are carried out. And I'm just going to assume here and talk about one type of idea for a planning mechanism, which is what we call a credit shelter trust. And this is a type of trust that I think we're going to see a resurgence in. Especially at the federal level. Here in Minnesota, we also have a state tax. So here in our home state, this is still a popular planning mechanism, to be sure. But I think we're going to see more utilization of these types of trusts. And the idea with something like this is that it allows married couples to be able to plan for the distribution of their estate in a tax efficient manner on spouse number one and spouse number two's passing. Okay. And so I think we're going to see this become a more popular way to plan. And in order to plan with this type of mechanism, we really are looking at what the couple has in terms of assets and how we can maybe change ownership of those assets and assign those assets to spouse one or spouse two in a way that makes sense. And we also want to plan to ensure that spouses can take care of each other. If that's goal number one, this type of planning mechanism would allow for that. And so the way that really looks is that you put together this trust. It helps you to avoid probate. If probate avoidance is a desired outcome, and oftentimes that is. Oftentimes couples and people want to avoid probate. And so this trust would help ensure that probate is not needed. But above and beyond that, what is really happening is when spouse number one passes, a certain amount of his or her assets would be placed into a sub-trust. We call it a family trust. And typically the amount of assets that funds that trust would be whatever the exemption amount is at the time, or what makes sense at the time based on taking that into consideration. And then realistically, the surviving spouse gets to be a trustee or a co-trustee on that bucket of assets, and they typically are going to be the primary beneficiary. So the goal is that those funds are available to the spouses for the duration of both lifetimes for their use. And when spouse 2 passes, then what we see, anything remaining in that trust would flow down, and that would go to kids, to grandkids, to other beneficiaries, and that is a tax-free transfer. What's left in that subtrust, that family trust, and the appreciation on those assets would then go to the family tax-free. Now, what happens with any excess above that exemption amount that funds the family trust, that would also go to the surviving spouse. It could be outright, or it could be in what we would call a marital trust. And again, very similar, surviving spouse can be a trustee or co-trustee and is generally they're the primary beneficiary. The difference is that what is left in that trust when spouse number 2 passes, that is not a tax efficient transfer to subsequent generations or beneficiaries. And so, realistically, we want to plan now so we know what you're looking at, because setting something like that up may not be enough. And for high net worth or ultra high net worth individuals, it frequently is not enough in terms of planning. And so then what we're looking at, and going back to what Michael said earlier, that we look at gifting. We want to start looking at lifetime gifts, okay? And that can be done with this annual exclusion amount, $19,000 per person per tax year. Married couples, you get to join forces, and so that's $38,000 per person per tax year. And you can exceed that if you are giving directly to medical or education institutions. But if you are in a position where the federal estate tax is an issue for you, that doesn't get you very far. Trying to gift $19,000 or $38,000 to certain individuals every year, it just doesn't really put a dent into things. And so then what we're looking at doing is crafting gifting plans. And that's the second mechanism that I think you're going to be hearing more about as the year progresses. How do you make these gifts now during life, during this year, that you can utilize that big exemption amount? And sometimes making a large gift to a child, a grandchild, to anybody, is inadvisable to make directly to that person in an outright fashion. Usually what we're talking about are substantial amounts. They can be life-changing. And there are other considerations that go into making those gifts that need to be carefully thought of. So can you afford to make that gift? Who is it going to? Are they able to handle the funds? Should it be placed into an irrevocable trust? Okay. And if it goes into an irrevocable trust for someone else's benefit and use, what type of terms need to be crafted and put into this trust to ensure that everything goes according to plan, really maybe into perpetuity? And so I think, Leonetta, you can speak to irrevocable trusts here, given the fact that you see these and work with these all the time. And they're, they can be wonderful tools. They can cover a lot of ground, but there can also be some, some pitfalls to try to avoid.
Yes. So there are a myriad of different types of irrevocable trusts. And one of the things that, as Rachel indicated, that it's extremely important that you work with your team of experts to determine which irrevocable trust works best for you and your family. I mean, you just don't want to pull one off the shelf and say, oh, this will work, because it doesn't necessarily work. So one of the things that, you would think of is, like a dynasty trust. And a dynasty trust, I mean, we do have them in Minnesota, but they don't go as long into perpetuity as some of the other flexible jurisdictions. In South Dakota, we can push those dynasty trusts out further. So basically what it is you've put the assets into the trust. It's irrevocable. And we're going to draft that document, or Rachel's going to draft that document, or your estate planning attorney is going to draft that document to make sure that those assets can get passed down generation to generation. So not only do your children benefit, your grandchildren, your great-grandchildren, and the lovely thing about this is it's passing these assets down without imposing those additional taxes that may be in place, like generation skipping taxes, gift taxes, estate taxes. So you can continue to pass those assets down tax-free. In South Dakota, we don't have fiduciary income tax. We do pay a, we do file a fiduciary tax return on the federal level. And there may be some tax that's applicable that needs to be paid at the federal level, but it's not on the bulk of the principal. It's the capital gains and the income that's being generated within that account. So there are lots of tax advantages.
Leonetta, real quick, does someone have to be a resident of South Dakota to have a South Dakota trust?
No, you do have to have a South Dakota trustee, however. So that's where, you know, Cornerstone could step in and assist because we are a South Dakota trust company. Our headquarters is actually in Sioux Falls, South Dakota.
And so for our listeners, realistically, if you're a Minnesota resident or you're a Wisconsin resident, you know, you are not precluded from putting together one of these trusts. They can still function to be powerful tools to help you reduce any tax burdens.
Yeah.
Yeah, I think you make me think of our great governor Dayton, the Dayton family.
Right, right.
Is the one that comes to example all the time. Pay his fair share. That's what he was always advocating.
Yes.
Right, right.
So, and one, you know, the other things that may be near and dear to your heart are if you and your family are charitably inclined. So we can set up an irrevocable charitable remainder trust that allows you and your family to collect the income from the trust over the course of the lifetime. And then at the last death of the income beneficiary, the assets that remain in that trust are distributed to charity. So you've, you know, benefited your family from the income stream that's being generated off of that trust, but you've also been able to leave a lasting legacy of your charitable intent to the charities that you may choose to give the balance of the funds to. One of the other ones that, you know, comes to mind that people don't, we don't always think about is if we have life insurance policies. And, you know, sometimes you accumulate life insurance policies over the course of time, but we can set those up into an irrevocable life insurance trust. If you own the insurance policy, we want to make sure that you're going to live past the look-back period so that we don't have any tax implication, or the insurance policy that you deposited into the trust gets pulled back into your estate. But the other option is you put the funds into the life insurance trust as a capital contribution, and we purchase a life insurance policy, excuse me, on your life. And at maturity, your family receives the principal of those life insurance proceeds without the estate tax consequence. Excuse me. There are some other options that we can go into in more detail. If you have any questions, please reach out to us. We can do an asset protection trust that protects the assets that go in there from creditors, or a self-settled trust that is protecting those assets from creditors. But one of the other large ones that Rachel and Michael have alluded to is a GST exempt trust. So those funds can go into that. They take advantage of the GST tax exemption, and the funds can pass for more than one generation from the grantor, like your grandchildren, your great-grandchildren, or great-great-grandchildren.
Corey, I think we have a question.
And Leonetta, I was gonna tag on that as far as the GST exemption, provide a little bit more clarity. So just so people know, the GST exemption is the same amount as the federal exemption. But note that, we had talked about this portability election. So portability is not available for GST exemption purposes. So if you don't use it during your life, you lose it. So just keep that in mind, is that does not carry over to the surviving spouse if they pass away, and you'll have that GST exemption as being lost in that case. Whereas if you did fund a GST trust, then you could use that GST exemption during your life and get that benefit for it being basically excluded for estate tax purposes for multiple generations.
Yeah, and just
Rachel,
to break that down a little bit, the GST tax, this is something that is a complex subject. And I think the best way I think about it is that, there was a time before this tax applied where, people would try to get really cheeky, and they'd skip a generation. They would say, well, we certainly don't want to leave massive amounts to wealth to perhaps our kids, because then they're going to have this in their bucket and they're going to get taxed. So we're going to be sly about it, and we're going to try to bypass them and just give it to our grandkids or subsequent generations. And well, the federal government didn't really appreciate that as much as those families did. Let's just put it that way. And so hence creation of this backstop, if you will, to try to prevent those types of transfers from happening without, folks paying their dues.
So just kind of stepping back, a big picture, and I'm going to round numbers. Right now, you can use strategies, a married couple, and it's just shy of 30 million. Is that exemption? So, and then if the provision does sunset at the end of the year, it's cut in half.
That's
right.
correct.
So technically, I could give or do some estate planning to take advantage of the exemption at the federal level that could potentially be gone next year. So it's important not to just to look at it. And then also, I think there's a specific question I was leading this. So really what you're talking about, and maybe you guys can touch on it, is let's say I do a great inventory. I pull together all my assets, my liabilities. Whether I'm over that amount or shy of that amount, getting together with the team here. What does that process kind of look like on the steps taken to figure out?
Well, I think high level, what we're looking at is, we want to take a deep dive and look at what someone has in the portfolio, right? Of this everything they have, right? They need to start looking at, perhaps if we're talking about a married couple, gifting 100% of one spouse's current exclusion amount. And maybe some of the other spouses as well. And then we're looking at, well, can they afford to do that, right? What assets do they have? Is this affordable for them in terms of giving away assets, accounts that they might be needing to live off of so that will take some time to decide what's the best way to go about this and what are the best assets to gift, okay, and chew up this exemption amount with. Michael, this is something we've talked about before, that there are consequences to making gifts of assets. And maybe you could touch just high level on the trade-off in terms of gifting these assets out of someone's estate, but then what does that mean from a tax perspective for those assets?
Absolutely. So I think touching base on what assets to give, it's important to, we don't want to necessarily get isolated just on an estate tax while, and Rachel's going to dive into more on the Minnesota side. But one thing that is important to note is that when you pass away with an asset, it gets a new basis, and that new basis is the fair market value as of your date of death. So, and I'm going to briefly touch on this, but so for Minnesota estate tax purposes, the rate fluctuates from 13 to 16%. Well, if you're facing a federal income tax and a state income tax at, let's say, 33 to 34% from the capital gains on the sale of a stock, it may make more sense to retain that asset in your estate, pay Minnesota estate tax, get the step up in basis, and then that way you don't owe any income tax when you ultimately dispose of that asset. So those have been planning things that we've done before. But remember that when you gift away an asset, there's some things that you can't do what you previously did with that particular asset. You lose a certain amount of control. And you may not necessarily be able to change the beneficiaries or change the ultimate disposition of that asset. So it's always important to review what assets, one, you're willing to part away from, if that be the case. And that way you can come up with a strategic plan of which assets to gift. And I'll kind of give you an example. And this is actually some planning that we've done before, is that, let's say someone, and I'll kind of dive into that details later, but let's say that someone gifts to an individual. Well, typically what happens is whatever their basis is becomes the basis to that donee. So let's say that I have a stock that's worth 250,000 and my basis in that is 100,000. Well, if I decide to gift that, then the donee takes my basis of 100,000, and if he later sells that asset, he's going to recognize the difference between, let's say he sells it for 250,000 and his basis is 100,000, he'll have a gain of 150,000. Now, let's say that I'm like, well, I want to hold on to this, and it really makes more sense for me maybe to gift him cash and me to keep this, appreciated asset that I haven't sold. And I pass away with that asset, and at my date of death, it's worth 250. And then he later sells it for 250. He has no gain in that situation. So kind of thinking about the income tax side of things as far as what you give, what its current basis is important. And I think this is going to come with our next presentation. So I'm going to keep you wanting more, hopefully. But there are certain trusts you can set up that, kind of help you mitigate that risk a little bit. So you can have a power of substitution within a trust. And what that does is, you're substituting an asset for an asset of equal value back, and one might have lesser basis than the other. So then You may be able to pull that asset with lower basis back into your estate. However, you've effectively transferred the value out of your estate because that's already been transferred. You're just basically trading hands, one asset for another. It's just one has lower basis. So if you have that asset when you pass, your heirs could get the income tax benefit of that basis adjustment. And
We've got a couple, I'm sorry, finish up, Michael.
go ahead, Corey.
We just had a couple questions, one for you, Rachel. I don't know if you see it.
Yes, I've got them pulled up. Let's see.
One is
All right,
GST.
GST trust, IRS caught on. Yeah, the IRS caught on to these things a long time ago. They are still allowed, for sure. There just are rules that you have to abide by. And in terms of, what the limitations are, I think, Michael, you alluded to this earlier, that the GST tax is tied in. It's the same amount as the lifetime state exemption gift and estate exemption amount, but it is not something that is portable. So that is the concern with that. And when you're structuring a GST trust, really, and this maybe could be something we touch on next time as well, but it has to be structured in a way that abides by the restrictions or the limitations, so that you don't have unnecessarily a taxable termination or a tax event occur, unless of course it's intentional. But we can touch on that for the next presentation maybe.
Then there's another question. I'll just read it. Are there any obvious strategies business owners can implement now to minimize future estate tax liability and ensure a smooth, tax efficient transfer of business ownership to the next generation? And just I'm gonna add something to that. It just reminds me of a client that it's a new client for us that we started working with, but his business makes about $4 million a year. So his estate today is under that $30 million threshold. However, in a few years, he'll definitely be tipped over that. So just that just makes me think of, you might not have that level of estate today, but in the near future, 2 to 5 years, you'll be over that threshold. So I'm gonna see who can take on that question.
Yeah, and so maybe I'll just, take first crack at this here, but in terms of business succession planning, huge topic. And that involves more than simply the tax piece, right? Because you've got to have, if we're talking about transferring the business or a portion of the business to the next generation, right? Family business succession, the statistics, generally aren't great the further you get from generation one in terms of viability of that business. So we really want to make sure that the next gen is ready to go, trained, they know what they're doing. We want to also talk about, if you have 4 kids, for example, and 2 are in the business and 2 aren't, one of the ways you can make this work is to gift shares to the subsequent generation. But then the question is that fair or equitable with respect to the other kids you may have? And so equalization in terms of giving or an inheritance is a question we want to make sure is thought of and planned appropriately for. But let's just say that doesn't apply. You've got 1 kid, you want to be really aggressive in terms of transferring shares of the business. Yes, then what we can look at is we can look at having that business appraised or evaluation done. We can start looking at, do discounts apply in terms of the value of that business, okay? And so lack of marketability, lack of control, we discount the value of the shares. We can get very aggressive in terms of transferring more wealth to the next generation at a time, right? And then once that business, the shares are transferred, perhaps the next generation just takes over, and any appreciation of the business grows, and that's great, right? Because the value is out of mom and dad's estate, and the appreciation is also out of mom and dad's estate. And if there are issues with, again, going back to what do you need for retirement? Because that often is the biggest asset in someone's portfolio. And the problem is that without capital, without a sale, how do mom and dad then retire? And so we have to talk about all of those things. So it could be done via gifting. It could be done via sale, partial gift, partial sale. We can leverage a lot of things, tools in the toolbox to make that work.
Yeah. And when you think about all of the steps that Rachel just laid out and things that she alluded to, it's not a decision that you can make today and decide that you're going to transition your business tomorrow. There are time commitments here, and it takes some time to be able to transition it properly so that everybody's taken care of, and you factored in all of the steps and components that need to be done. So it's probably something that if you're thinking about transitioning your business and retiring, it's a conversation that may take you 3 to 5 years. And, how do you do this? What's my next step? And so you have to be thinking about where you are in the planning process and make sure that you get your team involved so that they can do all of the analytics, crunch all the numbers, and the attorney can get involved and make sure that if you need buy-sell agreements or those types of things, that somebody has time.
And I think Rachel and Leonetta, you kind of nailed it, is that ensuring that there's a good succession plan, because if you don't have good management and things in place to ensure the longevity of the business, you wouldn't want to gift away a depreciating asset. So it's important that those things are appropriately structured and you have all those things in place before it's gifted away and things don't run as smoothly or as great as you thought it would be. And then you've kind of gifted away an asset that's higher in value today than 10 years from now. So it's important that all those things are managed well to have an outperforming asset.
Right. And especially if you are planning to structure that in a sale type of way, and you are expecting to have retirement income from that, there's not much of an income you can expect to get if that business goes under. So it's something to think about.
We've got a couple additional questions. Rachel, I'm going to throw this one your way. Can you comment on probate implications in Minnesota?
Sure. So probate implications from a tax perspective, it really doesn't matter. Okay, if you have a will or a trust, if your estate passes free of probate or not, that does not have any bearing on the estate tax ramifications that we've been talking about, or this window of an opportunity. All probate really is, it's just a court process to administer someone's estate after he or she has passed. One of the biggest, I would say, urban legends out there that I see all the time is that if you have a will, well, now your estate gets out of probate. Not true. Okay, a will is a ticket to probate. And you say who gets what, when they get it, how they get it, who's in charge. You can do the same thing in a revocable living trust. The difference is that, with a revocable living trust, we are putting your assets, we're working with retitling your assets now and setting them up so they are held by the trust, or they pass through the trust in a controlled fashion after you pass. Probate, even if you have nominated an executor or personal representative, guess what? That person has no authority to do anything until he or she files that will with the probate court and has been officially appointed by the court to serve. And now they have court papers they can take around to financial institutions or you know, so they can transact business, sell assets, do what they need to do.
Yeah, that's interesting. I mean, I have a client that the mother just passed away at 96, but she had a variety of annuities, several different investment accounts, different retirement accounts, kind of sprinkled everywhere, and going through probate. Just the amount of legwork that the children have to do to get it cleared. And the mother lived in another state, which even made it a little more problematic because now they're dealing with trying to do it in another state versus being local. So
Right.
revocable, regardless of the size of your estate, definitely revocable trust is something that you should be looking at. And it's kind of my understanding is just really how you title the assets.
Right, we want to ensure that things are titled appropriately and that the trust is funded, because, you know, I will say anytime we have a revocable living trust, we also have an accompanying pour over will with that to capture any oopses or assets that someone might have forgotten to put into their revocable living trust during their lifetime, so that then it's clear what happens with that asset when he or she passes.
And the other thing that I want to interject here so that you're thinking about it is a probate is a matter of public record. So unfortunately, somebody can, if they're you know, so inclined, can go down to the courthouse and request to read the court files so they know what assets you had, where they're going, and what the value of your estate was. A trust document, whether it's, you know, revocable at the time of your passing, it becomes irrevocable, but it also is a secure document. It's not a you know, we don't just give somebody a copy of your revocable trust because they asked for it. It's a privileged document, and we're not going to disclose information. So somebody is not going to know unless they are a beneficiary of your trust what assets are in there and who the beneficiaries of the trust are.
Thank you. One last question. We're coming up on top of the hour. The next question is all real estate owned jointly by spouses excluded from the value of the estate and taxes? And then there's a tail on piece. How about if it is held in an LLC where the only members are the two spouses?
So I can speak to that, Corey. So if, you know, in this particular case, it kind of, I guess my answer would change depending on if you're in a community property state or not, but assuming they're not in a community property state. So, you know, while the asset is included in your estate, or half the asset is if you own it jointly with your spouse, it's not going to have any tax consequence because the joint tenant with right survivorship is the spouse, so you'll get a marital deduction for it. The important thing about it, though, is that half of that asset will get a new basis to fair market value. So while it's included in the value of, say, if one spouse passes away, and you do get that basis adjustment, it wouldn't be subject to tax because of the marital deduction. Now, if it's held in an LLC, you know, really that's where, you know, the actual testamentary documents would dictate the ultimate disposition of that LLC interest. So that could potentially change unless there's, you know, some provision that ultimately directs, you know, that interest in the LLC go directly to the other spouse. So, you know, I guess one is that if it's jointly owned with your spouse, then the joint tenancy kind of tells where that asset goes, whereas the LLC interest might have a different disposition based off of a document that, a testamentary document.
Right, and I do want to add to that too, that, this spousal exemption that Michael was touching on here, and, that joint tenancy with right of survivorship, that automatic ownership by the surviving spouse, that can work in some instances. And in Minnesota, though, keep in mind, we have a lower estate tax threshold than what the federal government does. And we do not have portability here. Okay, so sometimes it is just completely the wrong type of ownership situation to put people into, because, if you are the surviving spouse and you just take advantage of this, right of survivorship, and then you get down the road and you say, wait a second, I only have $3 million, okay, that I can leave anybody I want to per Minnesota law. And my spouse had $3 million as well, but, he or she gave everything, he or she had to me. And so, maybe together we had $4 million, but now I have everything. And so I've got 4 million in my bucket. I have exceeded what I'm allowed to have or pass on tax-free by $1 million. And so in that type of situation, then just taking that or holding those assets in joint tenancy, that can be destructive. So, sometimes it works and sometimes it doesn't.
That's right.
No.
Sometimes the simple plan is not the most effective plan.
Right.
It can cost you more in the long run if some things aren't done right now, so to speak.
And that's a good point, because, those of us here on this webinar and on that professional team, we can do the planning now, or we can try to do it post-mortem or in an emergency type situation. But, in those types of situations, we really do not typically have the same options or meaningful choices that we would have otherwise been able to put in front of you. And generally speaking, it costs more. It's going to cost more to try to fix something than to do it right the first time.
Yeah, I always advise that it's really, you're making an investment in the plan versus the cost of not having a plan is definitely significantly a lot higher. But a great conversation, everyone. We are past the hour, but I do appreciate the panelists, Leonetta, Rachel, and Michael, your time and expertise. And I look forward to continuing this on June 4th. As I mentioned, we will be sending out an invite to everyone that was able to attend this webinar, and hopefully you got something out of it. I appreciate those that did submit questions. That makes it a better event and process for us. So again, thank you and have a good rest of the evening, and we'll see everyone June 4th.
Thank you.
Thanks, everyone.
Thank you, Corey.